Sit down. I didn't give you permission to speak, and the next time you interrupt a proceeding in my courtroom, I will hold you in contempt before you finish the sentence." The attorney sat. He had chosen the wrong courthouse to run this way. The woman in the back row had been watching him for 11 minutes, and she was the only person in the building with the legal authority to end his career. He hadn't looked at her yet. Judge Harlan Pressley was 62 years old and had been sitting on the bench at the Henrico County Circuit Court in Richmond, Virginia, for 22 of those years. He had been running Courtroom 4 for long enough that the bailiffs knew the precise angle of his chair when his patience was approaching its limit, long enough that the court reporters had developed their own internal rhythm for the silences he used as weapons. 3 seconds, 4, 5, before he leaned forward and said something designed to leave a mark. Long enough that the attorneys who appeared before him regularly had learned to keep their objections brief, their eye contact carefully managed, and their bodies angled slightly away from the bench, the way you angled away from something that hadn't decided yet whether to strike. The attorney he had just silenced was named Rachel Voss. She was 29 years old, 3 months into her first public defender appointment, and she had made the mistake of attempting to clarify a chain of custody objection before the judge finished his own sentence. The case was Commonwealth versus Aldridge, a felony breaking and entering charge, preliminary hearing on the suppression of evidence obtained during a warrantless search of the defendant's vehicle. The Commonwealth's attorney, a man named Keller, 40-ish, comfortable, who had appeared in this room enough times to have a preferred parking space, was making the argument that the automobile exception applied under existing Fourth Amendment doctrine and under Virginia Code, Section 19.2-56. He was at ease. He had made this argument before. He did not look at Rachel Voss. Voss was not at ease. She was holding her legal pad with both hands, the top edge pressed against the defense table, her knuckles white in the fluorescent light. Her client sat beside her, a man named Aldridge, 24, who kept his eyes on the table and did not move. Voss had prepared this argument. She had the citations. She had the case law. She had the suppression motion typed and tabbed and ready. What she had not prepared for was being cut off after 2 words, in front of a full gallery and a court reporter and 3 law clerks, who were pretending to look at their screens. Pressley let the silence extend. He let it extend the way someone opens a door very slowly, making the hinges creak. Then he turned back to the Commonwealth's attorney. "Continue," he said. Keller continued. From the back row, the woman with the yellow legal pad uncapped her pen. She wrote 3 words. Not a quote, not a case citation, not a summary of what had just happened in front of her, then recapped the pen and set it on the pad and went back to watching. The 3 words were timing, silence, pressure. She was not taking notes on the case. She was cataloging the tools. Her name, according to the intern badge clipped to the breast pocket of her second-hand blazer, was Celeste Drummond. The badge was a pale blue rectangle with her name printed in black, and the word intern beneath it in smaller letters. She had picked up the badge that morning from the security desk on the ground floor, the way the other 2 summer interns had, and she had clipped it to her blazer, and she had come upstairs, and she had not gone to the intern office where she had been told to wait. She had come to Courtroom 4 instead. She had been told the courthouse opened at 8 a.m. She had arrived at 7:42. She had read the docket sheet posted outside every active courtroom on the 2nd floor. She had identified which judge was holding the earliest morning session, and she had gone inside and taken the seat in the back row farthest from the door, and she had not moved since. The gallery was not crowded. A handful of people who appeared to be waiting for their own matters. A woman in the 2nd row, who was knitting something dark blue and apparently had permission to do so. 2 young men in ties who had the particular posture of law students on observation. One of them was writing furiously. The other was watching Pressley with an expression that was somewhere between fascination and adoration. Celeste Drummond did not look at either of them. She watched the bench. Pressley was still listening to Keller. His hands were folded on the bench in front of him, his reading glasses pushed up onto his forehead, his expression the specific expression of a man who has already decided and is waiting for the other person to finish out of courtesy. He was broad-shouldered and thick through the neck, with a complexion that went red when the temperature in the room rose even slightly, and a voice that had the quality of mahogany furniture, heavy, permanent, slightly dark at the edges. He had been appointed to the circuit court by a governor who no longer held office. He had been reappointed twice since then. He had the particular confidence of a man who has never lost anything he has tried to keep. Keller finished. Pressley nodded. The motion to suppress is denied. Vehicle stop was lawful under Terry and its Virginia progeny. Evidence is admissible. We'll schedule the trial date through the clerk's office. He turned slightly. Counsel, anything to add before I move to the next matter? He was not looking at Rachel Voss. The question was directed at Keller. Voss spoke anyway. Your Honor. Her voice was steadier than it had been. I would ask the court to note my objection for the record, specifically the Brady question raised in our written motion regarding the chain of custody documentation. The prosecution has not. The objection is noted. Pressley's voice did not rise. It narrowed. It has been noted. It will appear in the record as noted. If you feel the ruling is in error, counsel, Virginia Rule of the Supreme Court. 5A18 provides you with an avenue for precisely that concern. You may use it. In the meantime, he leaned forward, just slightly, and the room temperature seemed to drop. Do not interrupt a ruling that has been issued and entered. That is not a request. Voss stopped. She looked at her legal pad, then at her client, then at the table. Aldridge had not moved. The court reporter's fingers paused above the keys for exactly 1 second, then resumed. 3 rows back, in the aisle seat that gave her a clear sightline to both the bench and the gallery, Celeste Drummond added 2 more words to her legal pad. Repeat. Pattern. She was watching him the way you watch something you are going to have to describe precisely at a later date, with the attention of a person who does not expect to return for a second look. If you have ever watched someone use power the way other people use furniture, casually, without thinking, because it has always been there, keep reading. This story is about what happens when that stops working. Pressley moved on, but the morning was not finished with Rachel Voss yet. It rarely was. The way a room remembers a humiliation, Celeste had come to understand, is different from the way it remembers a verdict. A verdict is a conclusion. A humiliation is a temperature that lingers in the air long after the person who produced it has moved on to the next item on the docket. Voss sat through the rest of the morning session with the careful stillness of someone holding a position that costs them. She made 2 more arguments, brief ones, objections she was required by her duty of advocacy to raise even in a room that was not going to receive them, and on both occasions, Pressley responded in the same way. Not with anger, which would have been easier to absorb, but with the measured, slightly weary patience of a person explaining something simple to someone who keeps not understanding. The technique was precise. It made the argument seem incompetent rather than the ruling seem arbitrary. That was the specific function of it. Celeste had seen it before. She knew what it was. What she had not seen before, or not exactly this version of it, was the physical component. The third time Voss tried to speak, to place one final objection on the record before the matter was called as concluded, she stood from her chair and began. Your Honor, I would like to note for the... Pressley did not raise his hand this time. He leaned forward, slowly, deliberately, until his forearms rested on the edge of the bench. The movement brought his face several inches closer to the courtroom than it had been, and the shift changed the geometry of the room in a way that was not subtle. His voice, when it came, was quieter than it had been all morning. That was worse. Counsel? The word alone. Pause. Sit down. The difference between this and a normal instruction was the length of the pause and the direction of his gaze, which was on Rachel Voss's face with the specific quality of someone who has decided to make a person feel the full weight of exactly where they are. The gallery, which had been doing the gentle business of a public courtroom, shifting, coughing, checking phones under the rail, went completely silent. Voss sat down. She sat down quickly, and the quickness of it, the automatic compliance of her body before her mind had finished processing whether to comply, was the worst part of it. and Celeste suspected Voss knew that too, because her jaw tightened and she looked at her legal pad and did not look up for the next 7 minutes. Aldridge, beside her, had not moved since the hearing began. He had not spoken, had not been asked to speak, had not made any motion beyond the slight adjustment of his hands on the table when the ruling came down. He was 24 years old and had a criminal matter in a courthouse where his attorney had just been publicly taught not to stand up too quickly, and his face showed the expression of a person who had understood the dynamics of this room before he walked into it and was seeing his understanding confirmed. Celeste wrote nothing. Some things you don't write down. You carry them instead. On the way to the exit, Celeste passed within a few feet of where Rachel Voss was gathering her papers. Voss did not look up. Her hands were steady now, moving with the mechanical efficiency of someone who has learned to function through the aftermath. Celeste did not stop. She kept walking. She filed what she had seen in the place. She kept things that mattered, the place that was not the legal pad and not the black notebook, but the layer underneath both, the one that did not get put on paper until it was ready to be used. Pressley moved on. The next matter was a scheduling conference for a civil case involving disputed property boundaries in the western part of the county. The attorney on one side was sharp and organized. The attorney on the other side was a man in his late 50s with reading glasses on a chain and a briefcase that had seen better decades, and he made a procedural argument that Pressley found insufficiently grounded and said so with the particular patience of a teacher explaining something for the third time to a student who should have understood it the first time. The attorney with the old briefcase thanked the judge and sat down and looked at his hands. His client, a woman of about 70 sitting in the gallery with the posture of someone who had dressed for this occasion, watched the attorney sit down and looked as though something she had hoped for had just been quietly removed from the room. Celeste wrote nothing for that one. She capped the pen and held it between her fingers and watched. When the morning session recessed at 10:15 a.m., she stayed in her seat for a moment after the gallery emptied. The bailiff glanced at her on his way toward the side door. The court reporter gathered her equipment. One of the two young men in ties, the one who had been writing furiously, nearly collided with the knitting woman on the way out and apologized twice. The other one, the one who had been watching Pressley with the expression of adoration, lingered near the front of the gallery long enough to exchange a nod with the judge as Pressley stepped down from the bench. Pressley did not nod back. He did not look at the young man at all. But he said something brief, under his breath, to the court clerk standing at the side of the bench, and the young man, though he couldn't have heard it, stood up slightly straighter, as if he had. Celeste noted this and rose from her seat and walked toward the exit. In the hallway outside Courtroom 4, the air was different. The second floor of the Henrico County Circuit Court was a long corridor of pale stone floors and recessed lighting and the particular institutional quiet of a building that has processed enough human difficulty to absorb it into its walls. Courtroom 4 was at the far end of the corridor. The clerk's office was in the center. The records room and the document archive access were to the left, past a set of double doors that required a key card. The intern office was to the right, in a room that had previously been a storage room, and before that, according to Ruth Ellison, a jury deliberation overflow space that had not been used as such since the mid-90s. Celeste did not know who Ruth Ellison was yet. She found the intern office at 10:09 and opened the door. The room was smaller than it had looked from the hallway. 2 long tables pushed against opposite walls, each with a desk lamp and a power strip. A whiteboard on the far wall with a schedule written in red marker. A window that faced the interior courtyard, which was currently occupied by 2 maintenance workers and a cart of cleaning supplies. The fluorescent overhead light buzzed faintly in the upper range of its frequency, the kind of sound that you don't register consciously, but that accumulates over the course of a day into something heavier than noise. 2 people were already in the room. One was a young man sitting at the far table, with a laptop open, and a coffee cup from a place that did not appear to be within walking distance of the courthouse. He was broad-shouldered, light-skinned, with the kind of haircut that suggested regular appointments and the kind of shoes that suggested he'd had them specifically for this program. He looked up when Celeste came in and did not quite stand. "Brennan Holt," he said. "Duke Law, 3rd year." "Celeste Drummond." "Where are you from?" "Richmond," she said, which was true. "School?" She set her bag on the table nearest the window. "I'm not currently enrolled." Brennan Holt looked at her badge, then at her bag, which was a plain black canvas tote, institutional, the kind sold at campus bookstores for $12, then at her blazer, which was a good cut but not a recent season. "They take non-enrolled people?" he said. "Apparently," Celeste said. She pulled out her legal pad and set it on the table and uncapped her pen, and she had begun to review what she had written in the courtroom when the door opened again and the second person in the room, who had been sitting so quietly at the near table that Celeste had not registered her as a person rather than a piece of furniture, suddenly became more animated. The person who had come through the door was not another intern. She was about 50, with platinum hair cut precisely to the jaw, and a pantsuit the color of old ivory that had been pressed to a crease sharp enough to serve as a straight edge. She carried a clipboard and wore a lanyard with a badge that read Miriam Bexley, Court Administrator, in the same institutional font as Celeste's intern badge, but larger, and with a photograph. Her shoes were low-heeled and quiet on the stone floor. She came into the room in the manner of someone conducting an inspection rather than introducing herself, and she looked at Brennan Holt and nodded, and she looked at the quiet young woman at the near table and nodded, and she looked at Celeste with the particular expression of someone recalibrating an expectation. "Ms. Drummond," she said. "Good morning." Bexley's gaze moved to the yellow legal pad, then back to Celeste's face. "You were in courtroom 4 this morning." It was not a question. "Yes," Celeste said. "The intern orientation begins here, not in the courtroom." "I noted the time on the schedule. The orientation was listed for 10:30. I had time." Something crossed Bexley's expression. Not quite annoyance, not quite assessment, and then it was gone, replaced by the specific pleasantness of a person who has decided to be pleasant at cost. "We try," Bexley said, "to have our interns observe proceedings only when accompanied by a supervising attorney." For context, the courtroom experience can be, she paused, choosing the word, disorienting, for people who haven't had much exposure. Celeste did not confirm or deny her exposure. She recapped her pen. Bexley addressed all 3 of them. The third intern, the quiet one at the near table, was named Clara Nguyen, 2nd year at the University of Richmond School of Law, and she had the aspect of someone who had arrived precisely on time and prepared precisely the right number of questions, and was now hoping the rest of the summer would proceed in the same orderly fashion. She had a planner open in front of her, with color-coded tabs, and she was writing the date at the top of a fresh page when Bexley began to speak. The orientation lasted 35 minutes. Bexley covered building access. Their intern badges would get them through the main entrance and the intern office and the second-floor common areas, but not the records room, not the restricted archive, not chambers, and not the jury assembly floor. She covered dress code, which was professional at all times, no exceptions, no matter the temperature or the day of the week. She covered the assignment structure. Each intern would be given research projects by the supervising clerk, whose name was Lance Cordero, and those projects would be due on a rolling basis. They would have access to the courthouse law library on the 3rd floor from 8 a.m. to 5:30 p.m. on weekdays. They would not represent themselves as attorneys. They would not speak to litigants without a supervising attorney present. They would not access any case file without first checking the file request log with the clerk's office. The judge, Bexley said, sometimes observes intern performance directly. Judge Pressley takes the program seriously. He has written letters of recommendation for interns who distinguish themselves. He has also, on occasion, requested that interns be removed from the program for conduct he found inconsistent with the standards of this courthouse. She paused. "I mention this not to alarm you. I mention it so you understand the environment." Brennan Holt nodded with the enthusiasm of someone being told exactly what he had hoped to hear. Clara Nguyen wrote something in her planner. Celeste watched Miriam Bexley. Bexley held out 3 manila envelopes. Your first assignments are inside. Mr. Holt, you have a research project on qualified immunity doctrine, Virginia appellate treatment, last 5 years. Miss Ween, you have a statutory analysis of recent amendments to the Virginia Code property transfer provisions. She held out the 3rd envelope. Ms. Drummond, you have an initial inventory review of the pending research backlog in the archive. You'll be cataloging what's there and cross-referencing it against the active docket. Celeste took the envelope. The archive inventory was the most junior assignment possible. It was, in the parlance of summer intern programs everywhere, the organizational task that produced no visible output, required no legal knowledge, and could be assigned to anyone with a pair of hands and the ability to read handwriting that had been deteriorating since 1987. It was not the kind of assignment that got you a letter of recommendation. Celeste opened the envelope. Inside was a 2-page description of the backlog scope, a room number, and a handwritten note from someone named Cordero that said the archive key was at the main clerk's desk and would need to be signed out each time. She folded the note and put it back in the envelope and capped her pen. "Thank you," she said. Bexley gathered her clipboard and her pleasantness and departed. Brennan Holt watched her go, then swiveled his chair toward Celeste with the expression of someone who had just finished calculating something. "Archive inventory," he said. "Rough. It's fine. Cordero assigns that to people he doesn't know what to do with. Usually it goes to the college kid they bring in to help with admin in July." He paused. "No offense." "None taken." He leaned back. "I was here for orientation last summer, observation rotation. Pressley's a tough room, but he's good, sharp. He runs a clean docket." He said this the way someone says a thing they believe is a compliment, and also a way of establishing that they know enough to have an opinion. Celeste looked at her envelope. "He is certainly decisive," she said, and let it lie there. Brennan Holt looked at her for a moment, then went back to his laptop. The other person in the room who had been quiet this whole time, who Celeste now registered as the second young woman she had seen sitting with Brennan when she came in, not Clara and Gwyn, but someone else, someone she had missed in her initial count of the room, turned from the window. Her name, it turned out, was Tessa Garfield. She was blonde and polished in a way that suggested she had spent time thinking about exactly how polished she wanted to appear, and she had been on her phone for the entirety of Bexley's orientation, the phone kept below the edge of the table, in a way that would have been invisible to anyone not specifically looking. She put the phone away now and looked at Celeste with an expression that was carefully neutral in the way that perfectly calibrated expressions are always slightly off. "Archive inventory," she said. "I heard that's where they put people they're not sure about." "So I've been told," Celeste said. She picked up her legal pad and her bag and went to find Lance Cordero. The main clerk's office was in the center of the second-floor corridor, behind a counter that stretched the full width of the doorway. The counter was old and had been lacquered so many times it had taken on the color of ancient amber. There were 3 windows in the counter, each with a small placard designating its function. Only one was currently staffed, and the person behind it was a man of about 44 who looked up when Celeste approached with the expression of someone who has been interrupted in a task he considers more important than whatever you're about to ask. Lance Cordero was not a physically imposing man. He was medium height, medium build, with the particular quality of stillness that comes not from calm, but from the sustained effort of presenting calm. He wore a tie every day, according to the building's institutional memory, and his desk was organized in a fashion that suggested that disorganization was a moral failing rather than a time management style. He had a law degree from a school that no longer occupied its original building, and he had passed the Virginia bar on his 3rd attempt, which he did not mention, and he had been in this office for 11 years, which he mentioned frequently. "Drummond," he said, checking a list on his counter. "Yes, I'm here for the archive key." He did not move immediately. He looked at her badge. He looked at her legal pad. He looked at the envelope in her hand. "You'll need to sign the key log every time," he said, "both in and out. The archive closes at 4:30, no exceptions. The files in the backlog are organized by year and case number, but the system changed in 2009, so anything before 2009 uses the old coding." He said this quickly, like someone reciting a safety briefing on an airplane, in a tone that communicated he expected it to be ignored. Don't reorganize anything. Don't remove any document from the archive room without filing a formal access request with this office. Don't take photographs of the files. Understood. He slid the key log across the counter. She signed it. He unhooked a key from a board on the wall behind him, a physical key, old brass, attached to a heavy plastic tag the color of a safety cone, and held it out. When she reached for it, he did not let go immediately. "First time in a courthouse archive?" he said. "Something like that." He released the key. She had the clear impression that he wanted to say something further, that there was a sentence behind his eyes that he had decided not to deploy, and that the decision had been made for reasons that had nothing to do with efficiency. 4:30, he said. "No exceptions." She walked back down the corridor toward the archive room, which was in the left wing, past the double doors that required a key card she did not have. The archive room itself had its own door, which the brass key opened, and she stepped inside and found the light switch and held the door open for a moment while the overhead fluorescent tubes took their time deciding to illuminate. The room smelled like paper and time, and the specific chemical neutrality of storage that has been maintained at a consistent temperature for long enough that the smell has become the absence of other smells. Shelving units ran floor to ceiling on 3 walls, each labeled at the end with a range of years and case number prefixes. The 4th wall had a table and 2 chairs and a single outlet. The shelving for the most recent years, post-2009, was orderly and clearly labeled. The shelving for the years before 2009 used a coding system that was printed on a laminated card taped to the end of the first unit, in a font so small that reading it required standing close enough to feel the faint chill coming off the metal shelving. Celeste stood in the center of the room for a moment. She did not start with the recent years. She started with the laminated card. She read the old coding system carefully in its entirety, including the footnotes at the bottom that explained how cases involving sealed records were coded differently, and how cases from the criminal docket versus the civil docket were distinguished within the same year range. She read it the way she read everything, not to extract information, but to understand the structure. Then she went to the oldest shelving unit and began her inventory from there. She was not looking for anything in particular, not yet. She was getting a feel for what was here and how it had been handled, and whether there were gaps in the sequence that suggested something had been removed and not returned or transferred and not logged. This was, in the context of her ostensible assignment, exactly what she was supposed to do. In the context of the other assignment, the one that had brought her to this courthouse specifically, it was also exactly what she was supposed to do. She worked until noon, when a knock at the door was followed by Brennan Holt opening it without waiting for an answer. "Lunch," he said. "There's a place 2 blocks down. Cordero says we can take 45 minutes. I'll eat at my desk." He looked around the archive room with the expression of someone who has never voluntarily spent more than 10 minutes in a room like this and cannot imagine what would make someone choose it. "Your call," he said, and left. She heard his footsteps go down the corridor, and then the sound of a second set of footsteps, lighter, quicker, and then a pause outside the archive door, and then nothing. When she looked up, there was no one there, but the shadow under the door had shifted briefly, as though someone had stood there for a moment before moving on. She went back to the shelves. At 12:45, she replaced the files she had been reviewing, locked the archive door, returned the key to Cordero's desk. Cordero was not there, but a deputy clerk took it and logged it without looking up, and went to the 3rd-floor law library to eat her lunch and do something she had been planning to do since she arrived at the building. She had brought a sandwich. She also had a notebook that was not the yellow legal pad, a black hardcover notebook with narrow ruled lines that she kept in the interior pocket of her bag, where it was not immediately visible. She sat at a table in the back corner of the library where she could see the door and opened the notebook and began to write. The library was not empty. A paralegal from one of the civil law firms was at the reference desk asking a research librarian about a Virginia statute. Two people in suits were sharing a table near the window and speaking in the careful, low voices of people who have something to discuss and have been trained to be cautious about where they discuss it. A man in his 60s with white hair and reading glasses was asleep over a volume of the Virginia reports with the unbothered confidence of someone who has done this before and expects to be left alone. And, near the circulation desk, half visible behind a cart of recently returned volumes, was a woman Celeste had not seen before. She was old, not in the way of someone who had become old recently, but in the way of someone who had been old for long enough that it no longer surprised anyone, including her. Her hair was white and cut close to her head, and she wore bifocals on a chain around her neck that she was currently not wearing. She was shelving books from the cart with the methodical economy of a person who has done this motion so many times that her hands perform it independently while her attention goes elsewhere. Her attention, at this moment, appeared to go nowhere. And that was the thing that caught Celeste's attention in return, because nobody's attention goes nowhere. It always goes somewhere. Hers was just very good at appearing not to. She was wearing a badge that identified her as staff, but the name on the badge was too small to read at this distance. She did not look up. She shelved another book. She moved the cart 6 inches to the left and shelved 2 more. Celeste watched her for a moment, then looked back at her notebook. She wrote the date at the top of a fresh page. Then she wrote, in neat block letters, Inventory, Day 1. Then she began to write what she had found in the archive and what she had not found, and the specific sequence numbers that had been present and the ones that had not, and the year ranges where the spacing between case numbers suggested a gap that was either the result of a low-volume year or the result of something else. She wrote for 20 minutes. Then she closed the notebook and finished her sandwich and looked up. The woman with the white hair and the bifocal chain was gone. The cart was still there. 3 books sat on it that had not been there before, not waiting to be shelved, but waiting, as best Celeste could tell, to be returned to someone. The spines faced the wall. There are people who go silent because they are afraid, and people who go silent because they are watching. This story requires you to know the difference. Stay with it. Celeste went back downstairs. The afternoon brought 2 things: a second encounter with Cordero that confirmed what she already suspected about the procedural architecture of this office, and her first full afternoon session in Courtroom 4. Cordero was at his desk when she returned to sign out the archive key for the afternoon. She had a question, a specific question about the coding discrepancy she had found in the 2008 range, where 3 case numbers appeared to be out of sequence relative to the filing system described on the laminated card. It was a technical question. It had a technical answer. She asked it in exactly those terms. Cordero looked at her. The 2008 range was part of a transition period, he said. Numbers from that year were coded under the old system even after the transition decision had been made. It creates some apparent gaps. It's not actually gaps. The transition decision was made in what month of 2008? I don't recall off the top of my head. The laminated card says the new system was implemented effective January of 2009, but some of the numbers in the 2008 range appear to follow the new format. Cordero's expression did not change. It had the quality of something that has been specifically practiced not to change. I'll look into it, he said. In the meantime, the archive inventory task doesn't require you to resolve coding questions. It requires you to catalog what's present. If something appears anomalous, you note it. You don't investigate it. She held his gaze for a moment. Noted, she said. He gave her the key. She went back to the archive. The problem with the 2008 range was not simply the coding discrepancy. That was the surface of it, the visible edge. What was underneath, what she had been working around all morning without being able to approach directly, was a gap in the sequential record that should not have existed if the filing volume for that year was what the docket report suggested it was. The gap corresponded to a period of approximately 6 weeks. The case numbers on either side of the gap were present. The cases that should have occupied the space between them were not. She was on her knees in front of the third shelving unit from the back wall, working through the last section of the 2008 range, when she heard the archive door open. She did not stand immediately. She finished reading the case number on the folder in her hand and noted it in her inventory list and replaced the folder and rose. Cordero was standing in the doorway. He was not holding anything. He had not knocked. "Inventory is supposed to start from the current year and work backward," he said. She had been working from the oldest year forward, which was the opposite of what the inventory sheet prescribed. She had made the decision at the start of the day, for reasons she had not shared with Cordero, and the inventory sheet was general enough that it did not specify the direction. "I find it more useful to understand the structure from the beginning," she said. He came into the archive room. He was not a large man, but the room was small, and his entry changed the proportions of it. He walked to the shelf she had been working on and stood in front of it, not quite between her and the shelf, but close enough that accessing the shelf would require her to step past him. "This section," he said, "requires a secondary authorization for any files older than 15 years. I should have mentioned that at intake. I haven't removed any files. The authorization applies to opening the folders as well, for the inventory review." He pulled a form from the clipboard he had produced from somewhere. She hadn't seen him pick it up, which meant he had come in with it, and held it out. "You'd need to submit this to the senior clerk's office and get it countersigned before continuing in this section." She took the form. It was a standard-looking document, institutional header, boxes for case range and date and purpose. It required 2 signatures from the senior clerk's office and a statement of purpose. Processing time, according to the small print at the bottom, was 3 to 5 business days. 3 to 5 business days was the rest of the week and the beginning of next week. The authorization would effectively end her access to this section for the immediate term. She read the form in its entirety before responding. "Is this procedure listed in the intern program documentation?" she said. "It's courthouse procedure. I didn't see it in the materials Ms. Bexley provided. Ms. Bexley covers general building access. Archive access protocols are managed by the senior clerk's office." He held out his hand for the form, as if to take it back and fill it in on her behalf. The gesture was meant to be helpful. It was not. "I can start the process today if you want to hand it back." She did not hand it back. She folded it and put it in her bag. "Thank you," she said. "I'll submit it through the proper channel." He stood between her and the shelf for a moment longer than was necessary. Then he stepped back, not quite fully, and she moved past him, close enough that his jacket sleeve brushed her arm, and picked up her inventory sheets from the table and gathered her things. She had not found what she was looking for in this section. She was no longer certain that what she was looking for was here in the first place. But she had learned something more useful than a case number. She had learned where Lance Cordero's perimeter was, and she had learned how quickly he deployed it. She walked out. He pulled the archive door shut behind both of them, and it locked with the sound of the old brass mechanism engaging. "I'll make sure your authorization request gets into the queue," he said. "That's very helpful," she said, and meant none of it, and turned down the corridor toward the stairs. She was nearly at the stairwell when she heard him go back into the clerk's office. She paused at the stairwell door, not entering. The corridor was empty. She turned and looked back toward the double doors that led to the restricted wing, the wing with the restricted access archive, and the rooms that her intern badge did not open. She memorized the distance. Then she went upstairs. When she came out at 3:30, she returned the key and went upstairs and changed direction at the stairwell and walked to courtroom 4 instead of the intern office. The afternoon session had started at 2. She had missed the first 90 minutes. She took the same seat in the back row. The current matter was a pro se civil case. A man, 50-ish, in a dress shirt that had been ironed for this occasion, and a tie with a crease that suggested it had been knotted by memory rather than practice, who was representing himself in a property dispute against a corporation that was represented by 2 attorneys in suits that cost more than the man's car. The man's name, according to the docket sheet Celeste had collected from outside the door, was Theodoric Mans. He was making an argument about adverse possession, the legal doctrine under which a party who has occupied a piece of land openly, continuously, and without the owner's permission for a statutory period may acquire title to it. He had a folder of photographs. He had a handwritten timeline. He had clearly spent a very long time preparing this. He was not making it well. The problem was not that his argument was wrong. The argument was, as Celeste could tell from the back row, directionally sound, if imprecise. The problem was that he kept stopping, mid-sentence, mid-clause, to check his handwritten notes, and each stop broke his momentum and gave Pressley another opportunity to interrupt, and Pressley took every one. "Mr. Mans." Pressley's voice was patient in the specific way that patience can be a form of control. "What is the commencement date of the alleged adverse possession period? Your filing gives 2 different dates in 2 different paragraphs." Mans looked at his folder. He found the page he wanted. He started to answer. "The date, Mr. Mans. Just the date." "August of 2009, Your Honor, I believe. The date's in the—" "You believe. The records show—" "You are telling me that you have been in a property dispute for what appears to be 15 years, and you believe the commencement date." Pressley looked at the 2 attorneys for the corporation, then back at the man with the folder. He did not say anything for a moment. The silence was not kind. "Mr. Mans, I want you to understand something. This court is not a venue for imprecision. The statutory elements of an adverse possession claim under Virginia Code, Section 55.1-2300, require you to establish open, actual, exclusive, continuous, and hostile possession for a period of 15 years. Every element, not approximately, not you believe. Every element, with evidence, with dates, with documentation that holds up to scrutiny. What you have given me today does not rise to that standard." Mans was holding his folder with both hands. "Your Honor, if I could, I'm going to give you until the end of the month to amend your filing." Pressley's tone had dropped into something that sounded like magnanimity, but wasn't. "I would strongly encourage you in the interim to seek legal representation. The clerk's office can provide you with a list of legal aid organizations in the Richmond area. Court is adjourned for today." He brought down the gavel. The 2 corporate attorneys gathered their papers with the efficiency of people whose meter had stopped running. Theodoric Mans stood at his table for a moment longer, his folder of photographs still open in front of him. He closed it. He straightened his tie. He picked up his papers carefully, the way a person picks up something they have worked very hard to create and are now not sure they can salvage. Celeste watched this. She had seen this before. Not this case, not this man, but this dynamic. The power differential expressed not through cruelty exactly, but through the application of standards that cut differently depending on who they were applied to. She had seen it in the Eastern District. She had seen it in the magistrates' courts and the administrative courts, and the places where people showed up without lawyers because lawyers cost money and the alternative was handling it themselves. She had seen what it left on people's faces when they came out the other side of it. She wrote nothing on her legal pad. This was not something she needed to write down. What she noticed instead was Pressley's clerk, the young man from the morning, the one with the adoring expression, standing at the side of the courtroom and watching the man with the folder with an expression that was not unkind but was not moved. He was not moved by Theodoric Mans's folder or his tie or the 15 years he had apparently spent believing the law would give him something. He was noting, with the efficient detachment of a student who has absorbed a lesson, that the person without the attorneys had lost. His name, she had learned from the intern schedule Bexley had given them, was listed as a clerk extern, Holt, B. She had thought he was another intern. He was more than that. He had a role here, a relationship with the chambers, a reason to be standing at the side of Courtroom 4 at 3:50 in the afternoon, while every other intern was presumably upstairs in the intern office or the library. She adjusted something in her understanding and filed it. After Pressley left the bench, Celeste sat for another 3 minutes. This was the second time she had done this, remained after the room began to empty. and she was aware that it would be noticed if she made a habit of it. She was also aware that the 3 minutes she used sitting still in a room after everyone else left were the most useful 3 minutes she had access to, because this was when the room showed you what it actually was. What it actually was, at 3:50 on a Monday afternoon in June, was a room where the light came in at the wrong angle through windows that faced northwest and hit the wall above the jury box with an amber tint that made everything look warmer than it was. Where the jury box itself was scratched on the inner rail, at exactly the height a person's ring might catch if they turned their hand too quickly. Where the public gallery seats were bolted at intervals that suggested they had been designed for a time when the average person was 2 inches shorter and 3 inches narrower. Where the bench was higher than the standard, Celeste estimated by about 4 inches, in a way that was not illegal but was not accidental either. She stood, tucked her legal pad under her arm, and walked out. In the hallway, she almost collided with Brennan Holt. He had come around the corner from the direction of Chambers with the energy of someone moving quickly and certain that whatever was in front of him would yield, and when Celeste did not yield, she stopped, balanced, took 1 step to the side. He pulled up short, and his coffee cup tilted and the lid held. "Watch," he started. Then he saw who it was. Something in his expression reconfigured. "Sorry," he said, but he did not sound particularly sorry. He was close enough that she could see the ID clipped to his jacket. Not the intern badge, but a second badge, this one with a different color border that she recognized as the restricted floor access badge for Chambers and the second floor restricted wing. The kind you didn't get from Bexley's orientation envelope. The kind you got from someone who had decided to give it to you. He stepped around her without another word and continued down the corridor. She watched him go. Then she went to the 3rd floor library and found a table in the far corner and opened her black notebook and added a line to the day's entry. At 4:45, the library was beginning to empty in the way of a building approaching the end of its official hours, gradually, without drama, as if the space itself was releasing its occupants. The paralegal from earlier had gone. The 2 people who had been speaking in careful voices were gone. The man asleep over the Virginia reports had woken up, replaced the volume on its shelf with the precision of someone long familiar with where things lived, and departed without speaking to anyone. Celeste was working through a section of the Virginia reports herself, volume 214, covering recent appellate decisions on evidentiary matters, when a woman she had not heard approach set a volume on the return cart near her table. It was the woman with the white hair. Up close, she was taller than she had appeared from a distance, and her face had the quality of someone who had once been considered beautiful and had graduated beyond that into something harder to describe and more durable. She wore her court staff badge on a clip at her collar. The name on it read, Ellison, R., Clerk Services. She did not look at Celeste directly. She set the book on the cart, squared it against the others, and turned to go. Celeste said carefully, "Excuse me." The woman stopped. "The laminated card in the archive room, the old coding system. Do you know if there's a supplementary guide? The card mentions a secondary classification for sealed matters, but doesn't give the decoding table." Ruth Ellison looked at her, not with surprise, with something more careful than surprise. "The secondary classification table was internal," she said. Her voice was low and even. "It was never posted. If you needed it, you asked the senior clerk. And if the senior clerk wasn't available? Then you waited." She picked up 2 books from a return cart and moved toward the shelving unit nearest the back wall. She did not walk quickly. She did not look back. But she also did not, Celeste noted, simply walk away. She placed the first book. She placed the second book. She stood with her back to Celeste for a moment, and in that moment she said, at a volume precisely calibrated to carry no further than the space between them, "The archived materials from before 2009 have a secondary log, separate from the main inventory. It's not in the archive room." She pulled a 3rd book from the cart. "Thank you," Celeste said. Ruth Ellison said nothing more. She shelved the 3rd book and moved the cart to the next section and did not look back again. Celeste sat with this for a moment. Then she opened her notebook and wrote 3 words. Secondary log. Location? She was sitting with the notebook still open, reviewing the structure of what she had assembled in the last 8 hours, when a man she had not met yet came into the library and returned a volume to the circulation desk and turned to leave. And as he turned, he glanced at the tables in the back corner and saw her and stopped. He was about 55, with the bearing of a man who had been in institutional settings long enough that his posture had become a form of communication. His name badge read Oaks W., Deputy Chief Clerk. He looked at her badge, at the volume of Virginia reports open on her table, at the legal pad she had set aside, and the notebook that was not the legal pad. Drummond, he said, reading the badge. Intern. Yes. You're assigned to archive inventory. For the morning. I had some time before close. He looked at the open volume of the Virginia reports in front of her. Oaks was not a man who telegraphed his thoughts, but he had been working in this building long enough that he had developed, almost involuntarily, the habit of registering details that fell outside the expected pattern. What he was registering now was that the volume open in front of the archive inventory intern was not a general research volume. It was a specialized appellate decision compilation, and the tab she had it open to was an evidentiary section that was not introductory reading. Research for the inventory? He said. Background, she said. The archive has some older material that references evidentiary procedure from the pre-amendment period. It helps to understand the context. He looked at her for a moment longer. Then he said, apparently idly, Which decision? She turned the volume slightly toward him without looking away from him. The tab was marked. The page was open to a 2017 appellate ruling on the application of Virginia Rule of Evidence 2404B to prior bad acts in civil proceedings, a ruling that had itself been partially abrogated by a subsequent decision in 2020. Nicely framework, he said, the 2017 treatment, and the 2020 correction. She turned the page. The 2017 ruling reads more cleanly, but it overstates the scope. The 2020 decision limits the admissibility window significantly on the intent element. If you're reading the 2017 without the subsequent history, you end up with a different picture of what the rule actually allows. This is the moment people will look back on. The archive intern, on her first day, explaining the subsequent history of an appellate ruling to the deputy chief clerk. Remember this. Keep reading. Warren Oaks looked at the page. He looked at her. He said nothing for a moment, and in the particular quality of that silence, the silence of a man who has been in this building for 28 years and knows very well what first-day archive interns know and don't know, something shifted. Not dramatically. Not in any way that would be visible to someone watching from the other side of the room. But his hand, which had been resting on the edge of the circulation desk, moved slightly, and he looked at her badge again. And this time the look was different. The 2020 decision, he said carefully. Which panel? 3-judge. Unanimous. Judge Hargrove, writing for the court. She named the case without looking it up. It's not widely cited yet because it only applies when the prior act and the current claim share the same intent element. Most practitioners haven't needed it. But in the archive materials, if anything from the pre-2020 period cites the nicely framework on intent, you'd want to flag it for the subsequent history. Oaks did not write anything down. He did not have a notepad with him. He made the particular effort, visible to anyone watching carefully, of not appearing interested. Good evening, Ms. Drummond, he said. Good evening. He walked toward the exit. At the door he paused, not turning around, and said without looking back, The library opens at 7:30 a.m. for staff, 8 for interns. Then he was gone. Celeste closed the volume of Virginia reports and returned it to its place on the shelf. She collected her legal pad and her bag and her black notebook. The notebook went into the interior pocket first, before anything else, and she went downstairs and through the corridor and out through the main entrance into the late afternoon, which was warm and smelled of cut grass from the park 2 blocks north and the particular exhaust and stone smell of a city street in June. She stood on the courthouse steps for a moment. The building behind her was still open, light in the upper windows. 2 court staff members crossing the lobby visible through the glass entrance. The security desk with its single guard, reading something on his phone. She went to her car, which was parked 3 blocks away in a metered spot she had fed twice during the day. It was a navy blue sedan, 4 years old, unremarkable in every dimension. She sat in the driver's seat without starting the engine and opened the black notebook to the day's entries. She read what she had written. Then she read it again. Then she turned to a fresh page and wrote, "Day 1 complete." And below that, in the same neat block letters, the names of the people she had encountered, with a single descriptive note beside each. Pressley, Bexley, Cordero, Holt, B. Garfield, T. Ellison, R. Oakes, W. Beside Presley's name she wrote, "Consistent with documented pattern. Additional observations pending courtroom access." Beside Ellison's name she wrote, "Secondary log. Location unknown. Approach with patience." Beside Oakes's name she wrote, 28 years. Observant. Not hostile. Noted the citation without asking why. She closed the notebook and started the engine. She did not go directly home. She drove 4 blocks north, parked, went into a copy shop that stayed open until 8 p.m., and made 1 copy of the 2 pages of handwritten notes she had taken in the archive on the sequencing anomalies in the 2008 range. She put the original in her bag, and the copy in a separate envelope that she sealed. She addressed the envelope to a post office box in a name that was not hers, and deposited it in the mailbox on the corner. Then she drove home. Her apartment was on the 3rd floor of a building in Carytown, on the western end of the city, an area of bookshops and restaurant rows and sidewalks that filled with people in the evenings. The apartment was clean and organized in a way that had been deliberate from the day she moved in. A specific kind of order that served a specific kind of purpose. Nothing was decorative that was not also functional. The bookshelves were organized by subject and within subject by date of publication. The desk faced the window, but also faced the door. There was 1 chair at the desk and 1 on the other side of the room and a small table with nothing on it except a lamp. She made tea and sat at the desk and opened her laptop and spent 40 minutes reviewing materials she had already reviewed, this time with the context of what she had seen today. She was looking for something specific, had been looking for it for 6 weeks, and had not found it yet, which meant either it didn't exist in the form she expected, or it existed in the form she hadn't found. The archive's secondary log, which Ruth Ellison had confirmed existed, without confirming where it was, might be a thread worth pulling. At 9:12 p.m. she closed the laptop. She had been in the building for nearly 8 hours. She had spoken to 9 people. She had learned something about each of them, including the things they were trying not to show her. She was going back tomorrow. She had nearly finished her tea when her phone buzzed once with a message from a number she had saved under a 2-letter code. The message was 4 words. Conference scheduled. Thursday. Confirm. She confirmed. Thursday was the day the Virginia Judicial Inquiry and Review Commission held its bi-weekly case review meeting. She had 3 items she would be presenting. The first 2 were procedural updates, routine, the kind of thing that moved through the commission without significant discussion. The third was the preliminary file she had been building for 6 weeks on the subject of a sitting circuit court judge in Henrico County, a file that was still thin, that still had more questions than answers, and that would need to be substantially heavier before it was ready to support a formal investigative referral. She had begun to understand today that it might take a different shape than she had expected. The archive, the secondary log, the year that had bothered her in the sequence. Those were threads. Ruth Ellison was a thread. She had not come to Richmond for those threads. She had come for the pattern of recent conduct, the courtroom behavior, the due process implications, the consistent weight of the bench applied in one direction. But threads, in her experience, had a way of leading somewhere. She rinsed her cup and turned off the desk lamp and was ready for bed at 9:41 p.m. She was at the courthouse at 7:48 the next morning. The security guard who had been there yesterday was there again, reading the same phone. The lobby had the particular quality of an institutional space before it fully wakes. Lights at half, the distant sound of a vacuum somewhere on the upper floors, the smell of coffee from a break room whose door was not quite closed. She signed in and clipped on her badge and rode the elevator to the second floor. The intern office was empty. She had expected it to be empty. She set her bag on the table nearest the window and took out her legal pad and uncapped her pen and reviewed the 3 words she had written the day before. Timing, silence, pressure. She turned to a fresh page. She wrote, Day 2. Secondary log. The archive closes at 4:30, but the building does not. She closed the pad. At the far end of the corridor, past the stairwell and past the double doors that required the restricted keycard and past the door to the clerk's office, Courtroom 4's lights were already on. Through the small window in the courtroom door, a rectangular panel of reinforced glass at head height, she could see the bench was empty, but the lights were on and the court reporter's station was set up. And, on the table outside the courtroom, clipped to the docket post in the way all the day's docket sheets were posted each morning, was a manila envelope. On the outside, in the careful handwriting of someone who had been doing this for a very long time, was a single line. It was not addressed to her by name. It was addressed to Research, Archive, Backlog. She stood in the corridor for a moment and looked at the envelope. Then she took it down from the post, because it was addressed to her function, if not to her name, and she opened it. Inside was a single page. It was a copy of a court docket schedule, not current, not from this year. The paper had the off-white quality of something that had been photocopied from an original that was itself already old. The date at the top read, March 14th. No year was listed on this copy, but the formatting and the typeface and the absence of certain fields that had been standardized in later years placed it in a period before the 2009 system change, possibly earlier. On the schedule, 7 hearings were listed across 2 courtrooms. 6 of them were unremarkable: scheduling conferences, motion hearings, 1 initial appearance in a civil matter. The 7th, in the second courtroom listed, was marked with a notation in the margin. The notation was in pencil, faint enough that she almost missed it, and it read only, HC4, HC4, Courtroom 4. The hearing in the second courtroom was listed under a case number. The case number, in the old coding system whose structure she had memorized from the laminated card yesterday afternoon, corresponded to a criminal docket filing from the relevant year range. She could decode the year from the number if she cross-referenced it with the laminated card guide. She would do that in the archive today. She put the page back in the envelope and put the envelope in her bag, in the interior compartment next to the black notebook. She looked up and down the corridor. It was empty. No sound from the intern office. No sound from the clerk's office. The courtroom at the end of the hall had its lights on and its bench unoccupied. Somewhere in this building, someone had left this page for her to find, and that person had either made a mistake or had decided, after a very long time of deciding otherwise, not to. She walked back to the intern office and sat down at her table and uncapped her pen and did not write anything for a full minute. She had been sitting for perhaps 3 minutes when she heard footsteps in the corridor, unhurried, deliberate, and Tessa Garfield came into the room. Tessa did not look at Celeste immediately. She went to her own table, set down a coffee she had picked up from somewhere, and took off her jacket with the careful method of a person executing a routine. Then she sat, opened her laptop, and looked at the screen. The room was quiet. After a minute, Tessa said, "You were in the courtroom again this afternoon." "For a while. Pressley doesn't like it when interns observe without being invited." She said this in the tone of someone sharing useful professional intelligence. "He told Brennan that last summer. The observation rotations are supposed to be arranged through Bexley." "I'll keep that in mind." Tessa turned slightly in her chair to face Celeste more directly. She had the particular self-possession of someone who has practiced seeming casual. "What are you working on? The archive thing?" "Yes." Cordero told Brennan that you were asking about the old coding system, that it's pretty far outside the scope of the inventory project. Celeste looked at her legal pad. The inventory requires understanding what's there, she said. The coding is part of what's there. Tessa nodded in a way that was not agreement. She looked at the yellow legal pad. Celeste had left it on the table when she went to the archive that morning, which she had done deliberately, because the legal pad contained nothing. 3 words from the courtroom and a handful of inventory numbers that would tell an observer nothing except that she was doing exactly what she had been assigned to do. What Tessa was actually interested in was the bag. Celeste had known this since the morning, when she had come back from the corridor and found the chair beside her work table pushed slightly out of alignment. Not by much, an inch or two, but she had noted the position when she sat down, and she had noted the change when she returned. The bag had been moved. The zipper was not closed in the same position it had been in when she left. Someone had looked inside the bag. The bag contained her lunch container, a spare pen, her phone charger, and the manila folder from Bexley's orientation. It did not contain the black notebook, which was in the interior pocket of her blazer, which she had worn all day. It did not contain the inventory notes, which were in the same interior pocket. It did not contain anything she would not have wanted Tessa Garfield to find. She had known someone would look. It was Tuesday of her first week. She had been more interesting than she should have been, to more people than she should have been interesting to, and the consequence of that was people going through her bag while she was in the corridor. She picked up the bag now and set it on her lap. "How's the qualified immunity research?" she said. Tessa turned back to her laptop. "Fine. There's a lot of it." "There is," Celeste agreed. She stayed in the intern office until 5:15, working through a section of background research she had been assembling in her head since the morning. She did not write it in the legal pad. She did not open the black notebook. She sat at the table with the legal pad in front of her and a pen in her hand, and appeared to anyone who looked in the door to be working through something methodical and unremarkable. At 5:15, she put on her jacket and picked up her bag and said good evening to Clara Nguyen, who had arrived at some point in the afternoon and was still at her table with the color-coded planner, and walked out. She was at the stairwell when she heard the sound of something hitting a floor. Sharp, object strikes stone, and turned. At the far end of the corridor, outside the records room, Brennan Holt was crouched picking up a stack of folders that had apparently spilled from a pile he was carrying. He was 20 feet away. He had not looked up yet. She waited. When he did look up, she was still there, and the expression that crossed his face before the neutral one replaced it was not quite what she had expected. It was not irritation. It was something that she had seen before in people who have decided they are in competition and have realized they may have underestimated the other party. It lasted approximately 2 seconds. He straightened with the folders and walked to the clerk's office without speaking. She turned and went down the stairs. The building's lower corridor was different at 5:15 than it had been at 8 in the morning. Emptier, slightly warmer from the accumulated heat of a full day of occupancy. The lobby security desk now staffed by a different guard who was reading the same kind of content on his phone as his predecessor, but on a different app. She signed out. She went through the glass doors. She stood on the courthouse steps for a moment in the late afternoon air. Then she went to her car. Her apartment was on the 3rd floor of a building in Carytown, on the western end of the city. The apartment was clean and organized in a way that had been deliberate from the day she moved in, a specific kind of order that served a specific kind of purpose. Nothing was decorative that was not also functional. The bookshelves were organized by subject, and within subject by date of publication. The desk faced the window, but also faced the door. She made tea and sat at the desk and opened her laptop and reviewed materials she had already reviewed, this time with the context of what she had seen today. She was looking for something specific, had been looking for 6 weeks, and had not found it yet, which meant either it didn't exist in the form she expected, or it existed in the form she hadn't found yet. The secondary log Ruth Ellison had confirmed existed, without confirming where it was, might be a thread worth pulling. At 9:12 p.m. she closed the laptop. She had been in the building for nearly 9 hours. She had learned something about each person she had spoken to, including the things they were trying not to show her. She was going back tomorrow. Her phone buzzed once with a message from a number she had saved under a 2-letter code. Conference scheduled. Thursday. Confirm. She confirmed. Thursday was the bi-weekly case review meeting of the Virginia Judicial Inquiry and Review Commission. She had 3 items to present. The third was the preliminary file she had been building for 6 weeks on a sitting circuit court judge in Henrico County. A file that was still thin, that would need to be substantially heavier before it was ready to support a formal investigative referral. Today had given her threads she hadn't expected. Threads had a way of leading somewhere. She rinsed her cup, turned off the desk lamp, and was in bed by 9:41. She was at the courthouse at 7:48 the next morning. The intern office was empty. She set her bag on the table and took out her legal pad and reviewed the 3 words from the day before. Timing, silence, pressure. She turned to a fresh page. She wrote, Day 2, secondary log. The archive closes at 4:30, but the building does not. At the far end of the corridor, Courtroom 4's lights were already on. Through the small, reinforced window in the door, she could see the bench was empty, but the court reporter's station had been set up. The docket post outside the door held the morning's schedule, and something else. A manila envelope clipped to the post alongside the official docket, addressed in careful handwriting to Research, Archive, Backlog. She took it down. She opened it. Inside was a single page. A copy of a court docket schedule, old, off-white, the formatting placing it in a period before the 2009 system change. The date read March 14th, no year given. 7 hearings listed across 2 courtrooms, 6 unremarkable. The 7th carried a margin notation in faint pencil. HC4, Courtroom 4. The hearing's case number, decoded through the laminated card structure she had memorized yesterday, corresponded to a criminal docket filing from within the year range that matched the gap in the archive sequence. She put the page in her bag, in the interior compartment beside the black notebook. She looked up and down the corridor. Empty. Somewhere in this building, someone had left this for her to find. Someone who had either made a mistake or had decided, after a very long time of deciding otherwise, not to. She walked back to the intern office and sat down and wrote 3 words. The secondary log, HC4. She capped the pen. She heard footsteps in the corridor. Deliberate, unhurried, the steps of someone who knew exactly how much time they had. And then a pause outside the door. And then nothing. She did not look up. She was already thinking about what came next. Part 2. The motion is denied. If you'd like to understand why, I suggest you read the statute before you file the next one, because this court does not have the patience to educate counsel on material they should have mastered before taking the case. The attorney who had filed the motion sat down without a word. He was 50 years old and had been practicing civil litigation for 23 of those years, and the particular quality of the silence he maintained, not wounded, not defiant, but sealed, was the silence of a man who has calculated, with the precision of long experience, that no response available to him in this moment would cost less than silence. The case was a breach of contract dispute involving 2 commercial landlords and a tenant who had vacated premises mid-lease. The attorney had filed a motion in limine seeking to exclude certain financial records on the grounds that they had been produced in violation of the discovery timeline established by pretrial order. It was not an unreasonable motion. The timeline violation was real, 14 days late, documented, uncontested by opposing counsel. What the attorney had not adequately anticipated was that Pressley considered late discovery production a matter between the producing party and their counsel, not a matter requiring the exclusion of otherwise relevant evidence, and that Pressley's position on this had been stated clearly in a published opinion from 4 years prior that the attorney had apparently not reviewed before filing. That was the substance of the denial. It had a legal basis. The denial was not wrong. The manner of it was different from the substance. The manner contained the specific ingredient that Celeste had been cataloging since Monday, the public diminishment, applied with the light precision of someone who has practiced it long enough that it no longer requires effort. The reference to reading the statute, the reference to mastery, the reference to the court's patience, as though the court's patience were a finite resource that the attorney in front of him was depleting through incompetence, rather than a judge's patience being a basic professional obligation. The attorney who had filed the motion sat down without a word. He was 50 years old and had been practicing civil litigation for 23 of those years, and the particular quality of the silence he maintained, not wounded, not defiant, but sealed, was the silence of a man who has calculated, with the precision of long experience, that no response available to him in this moment would cost less than silence. Celeste Drummond, in the back row of Courtroom 4 at 8:54 on Wednesday morning, wrote one word on her legal pad: 11. That was the count. 11 attorneys in 6 days of observation across morning and afternoon sessions. 11 attorneys who had filed, argued, or raised something that Pressley had dismissed with the same compound gesture, the lean forward, the quiet voice, the reference to competence, that she had first catalogued on Monday morning. The gesture was not identical each time. It calibrated itself to the size of the room and the status of the person receiving it. With Rachel Voss, it had been slower, more deliberate, because Voss was young and the point was durable. With the 50-year-old civil litigator, it was faster, more surgical, because the point here was not duration, but efficiency. In both cases, the geometry was the same. The bench was elevated, the voice was low, and the person on the receiving end was made to feel, in the middle of a public room, that the ground under them had become uncertain. 11 times in 6 days. She capped her pen and looked at what she had written. The preliminary file she had been building for the commission had, before this week, contained mostly procedural observations, documented instances, secondary accounts from former clerks, the quantitative pattern of reversal rates on due process grounds. What it had not had until this week was direct observation. First-person notation of specific incidents, time-stamped, documented in real time by someone with the legal standing to carry them forward. It had that now. She turned to a fresh page and began to write the date and the case name and the specific language Pressley had just used, which she had memorized in the moment it was spoken. The commission met tomorrow. She had a file to update tonight. From 3 rows ahead of her, in the section of the gallery reserved for court staff and supervised observers, a young man in a blue suit turned his head just far enough to register that she was still there, then turned back to face the bench. He had been doing this, the fractional turn, the register, the return, at intervals since she entered the room, and the interval had shortened from approximately 12 minutes on Monday to approximately 6 minutes this morning. Brennan Holt had not decided yet what to do about her, but he had decided she warranted watching. She wrote down the case citation and closed the pad and waited for the session to end. The morning recess came at 10:20. Celeste stayed in her seat. The gallery emptied in the usual sequence. Attorneys first, then observers, then the court staff in their measured, unhurried way, and she sat with her hands folded on her legal pad until the room was down to the bailiff and the court reporter, and then she stood. She walked out through the side door, the one that opened onto the staff corridor rather than the main public hallway. She had used this door twice before. It was not prohibited. Her intern badge got her as far as the staff corridor, and the staff corridor connected to the stairwell on the east side of the building, which was the faster route to the archive. She was 3 steps into the corridor when she heard the door open behind her. "That's the staff corridor." She stopped. She did not turn immediately. The voice belonged to Brennan Holt. She turned. He was standing in the doorway with one hand on the frame, his badge at chest level, the restricted access border on it visible even from this distance. His expression was the one he had been practicing all week, pleasant, faintly helpful, calibrated to carry no fingerprints. "I know," she said. "Access is supposed to be through the main hall for interns." "The badge works," she said. "I checked on Monday." A pause. He was calculating something. Pressley doesn't like it when interns use the staff rotes. He said this in the same tone he had used to tell her about the observation schedule. The tone of professional intelligence. The tone of someone doing you a favor by telling you the unwritten rules. He mentioned it to me yesterday. Pressley mentioned the staff corridor to you. He mentioned intern access generally. She looked at him. He filled the doorway without appearing to try. He was larger than she had initially registered, or perhaps the corridor's proportions were making him appear larger, or perhaps she was simply registering now something she had only noted before without fully processing, that Brennan Holt occupied space with the specific intention of being noticed occupying it. "Thank you," she said. "I'll keep it in mind." She turned and walked back through the main door into the public corridor. She did not change her route because of what he had said. She changed her route because she had registered what she needed to from the staff corridor and had no immediate reason to return. There was a difference, and she held it clearly. The archive was accessible from the public corridor with a detour through the clerk's office. She took the detour. Cordero was behind the counter. He gave her the archive key without a secondary authorization lecture today, which meant either the lecture yesterday had accomplished what it was intended to accomplish, or he had received information this morning that caused him to adjust his approach. She signed the key log and went to the archive. In the archive, she returned to the 2008 range. The case number from the HC4 envelope had kept her awake for 2 hours the night before, not because it was unreadable. She had decoded it within 20 minutes of returning home, using the laminated card's structure and a secondary reference she had brought with her from a library database, but because of what the decoding suggested. The case number corresponded to a criminal filing from early in the year. The case type code, embedded in the middle digits, indicated a felony matter. The court division code indicated Courtroom 4. She had not been able to find the case in the main archive inventory because the main archive inventory did not list it. The sequential gap she had identified on her first day, the one Cordero had attributed to coding transition, corresponded exactly to the range within which this case number should have appeared. The case was not missing from the system. It had been removed from the visible index. She pulled the folders in the range on either side of the gap and spread them on the archive table and worked through the cross-reference structure, looking for any document that referenced the case number from the envelope as a related proceeding, a companion case, or a transferred matter. In the second folder, she found it, a single entry in a transfer log, dated 14 months after the original filing, indicating that the associated case materials had been moved to what the log called restricted supplementary storage per senior court administrative authorization. The authorization bore 2 initials. The first initial was P. The second was H. She set the folder down and sat with that for a moment. Then she photographed the page with her phone, not the archive camera she had been forbidden from using, but her personal phone, which she had placed on the table at the start of the session in plain sight, because she had been warned not to take photographs of the files and had not been warned about the transfer logs, which were technically a separate category of document. She replaced the folder. She spent the next 2 hours working the archive inventory as assigned, methodically, without haste, noting what was present and what was not, and writing the inventory numbers in the format Cordero had specified on her first day. She was thorough, and she was complete, and she did not rush. And when she returned the key at 12:30, she handed Cordero a 3-page handwritten inventory of the morning's work that was exactly what the assignment required. He accepted it without comment. She went to the library. Warren Oakes was at the reference desk when she arrived. He was not asking for anything. He was standing at the desk reading a document he had brought with him, the way a person stands at a counter when they are using the surface but not the service. He did not look up when she came in. She took a table in the back corner, as she had on Monday, and opened her black notebook and began to update the commission file. She was writing for perhaps 20 minutes when Oakes came to the back corner. He did not take the chair across from her. He stood at the end of the table, at a distance that was social rather than conversational. "How's the inventory?" he said. "Progressing." "Cordero said you had questions about the coding system." "I had a question. He answered it." Oakes nodded in the same way he had nodded in the library on Monday. The nod of a man who is filing information rather than responding to it. He looked at the black notebook, which she had not closed when he approached, but which she had angled so that the open page was not visible from where he stood. "The archive transfer logs," he said. "Do those fall under the inventory scope?" She looked at him. He was asking in the tone of a man who already knows the answer to the question he is asking and is asking it to determine whether she knows it too. "The assignment sheet specifies case files and supporting documentation," she said. "Transfer logs are administrative records. The scope is ambiguous." Cordero would say they're out of scope. Cordero would be technically correct. The authorization for archive research under Section 17.1-913 of the Virginia Code distinguishes between investigative records and administrative process documents. Transfer logs are administrative process. She said this naturally, in the middle of her sentence, and then continued to the next point, and it was not until 2 seconds after she had finished that she registered what she had said and looked up. Oakes had gone very still. Section 17.1-913 of the Virginia Code was not a provision that appeared in law school curricula, in bar exam preparation, in the materials covered by any standard legal research course. It was the confidentiality and procedural authorization provision of the Virginia Judicial Inquiry and Review Commission's enabling statute. It was not a provision that archive inventory interns cited in casual conversation about the scope of their assignment. She held his gaze. He held hers. Neither of them said anything for a moment. Then Oakes said, at a volume that did not carry past the table, "Where did you go to law school, Ms. Drummond?" "I'm not currently enrolled," she said, which was the same thing she had told Brennan Holt on the first day, and which was equally true and equally incomplete. He did not pursue it. He looked at the black notebook once more, the angle, the size, the hard cover, and then he said, "Good afternoon," and walked back to the reference desk. She watched him go. She closed the notebook and put it in her jacket's interior pocket and stayed in the library for another 20 minutes, doing nothing, which was the most deliberate thing she did all day. There are people who notice the wrong thing, and people who notice the right thing, and people who notice the right thing, and then spend years pretending they didn't. Warren Oakes was about to find out which kind he was. She came out of the library at 2:15 and found the hallway in a state she had not seen before. 3 people were standing in the corridor outside Courtroom 4 in a loose cluster, not a group, not a conversation, but the particular spatial arrangement of people who have received the same piece of information at approximately the same time and have not yet decided what to do with it. One of them was Tessa Garfield. One of them was Clara Nguyen. The third was a young man from the clerk's office, whose name she had not learned. She approached. "What happened?" she said. Tessa answered. "Pressley held someone in contempt." She said this with the particular neutrality of someone who does not want to appear as unsettled as she is. "In the morning session, one of the public defenders, she's still in there." "He issued the order?" "Yes." Clara Nguyen was holding her planner against her chest. "He gave her an hour, fined her $400. Celeste looked at the courtroom door. The reinforced window showed the room lit and occupied. "What was the basis?" she said. She kept arguing after the ruling. Tessa paused. "He said it was contemptuous conduct." Celeste had been in the library during the post-recess session. She had not been in the courtroom. She stood outside the door and thought about the 50-year-old civil litigator from the morning session, and Rachel Voss from Monday, and the 8 attorneys whose similar experiences she had documented between those two, and the number on her legal pad that was now 12. She pushed open the door. The room was not crowded. A handful of people in the gallery, 2 attorneys at the defense table who appeared to be waiting for something, and at the center of the room, at the defense table, a woman in her mid-30s who was sitting with her hands folded on the table in front of her, and her back very straight and her eyes forward. She was not crying. She was doing the thing that takes more strength than crying, which is remaining entirely still in a room that has just publicly diminished you and refusing to give the room the reaction it is waiting for. Celeste came in and took the back row and sat. The woman's name, according to the docket sheet, was listed as counsel for defendant in a criminal matter. Voss R. It was Rachel Voss, the same attorney from Monday's morning session. Pressley was at the bench. He was reviewing something in front of him, not looking at Voss, not looking at the room, in the specific way of a person who has made his point and is now waiting for the clock to run. The hour ran. At the 45th minute, Pressley looked up. "Ms. Voss," his voice was even, "you'll want to consider your conduct going forward. The fine is payable to the clerk's office within 30 days. We're adjourned." He stood, and the room stood, and he walked through the side door. Rachel Voss remained seated for exactly 10 seconds after the room began to move. Then she gathered her papers. She was efficient about it, not hurried, not slow. She zipped her bag. She picked it up. She walked out the center aisle. At the door, she passed within 2 feet of Celeste, who had not moved from the back row, and their eyes met briefly. Voss's expression said nothing readable. She was past the management of expression. She went through the door, and the door closed. Celeste sat in the empty courtroom for a moment. She added to her count 13, and beneath that number she wrote a different number, 400. The fine, which Voss would pay, because the alternative was a finding of non-compliance that would go in her professional record, and which Pressley knew she would pay, and which had been calibrated at precisely the threshold that is high enough to be meaningful and low enough to be survivable. She went back to the intern office. Brennan Holt was at his table. He had a legal pad in front of him, and he was writing on it with the specific industry of someone who wants it to be apparent they are working. When Celeste came in, he looked up and said, "Voss?" "Yes." "She's been in front of Pressley 6 times this month. She keeps re-arguing after rulings." Celeste set her bag on the table. "She keeps placing objections for the record," she said. "That's different from re-arguing. Pressley doesn't think so. Pressley's characterization doesn't change what she was doing procedurally." Brennan looked at her with the expression of someone who has decided to reconsider whether to be pleasant. He tapped his pen on the table once. Then he said, "You should be careful about how you talk about judges in the building." "I'm talking about procedure," she said, "not the judge." "People hear things," he said. "In a courthouse. They hear more than you think." She looked at him. He looked back. It was not the hallway this time. No door frame, no physical blocking. But the quality of what he was doing was the same. He was occupying the space in a particular way and pointing at its edges. She opened her legal pad and uncapped her pen. "Thank you," she said. "I'll keep that in mind." He watched her for another few seconds, then turned back to his work. Tessa came in at 4:15 and sat at her table without speaking. Clara Nguyen arrived at 4:30 with the color-coded planner and the particular exhaustion of someone who has had a day that did not match what they had planned for. The intern office was quiet for the last hour of the workday, which was the quiet of 4 people in a small room who are all thinking about different versions of the same problem. At 5 o'clock, Pressley's clerk appeared in the doorway of the intern office. He was not Brennan Holt. He was a different person, older, mid-50s, who looked in from the doorway and addressed the room generally. "Judge Pressley wants to extend an invitation," he said. "Informal observation rotation. Tomorrow morning, 10 o'clock. Chambers. Open to the interns." He looked at each of them in sequence. Then he left. Clara Nguyen wrote something in her planner. Tessa looked at Brennan. Brennan looked at Celeste. Celeste looked at the door the clerk had just gone through and thought about what tomorrow morning at 10 o'clock meant in the context of what she was building and what she still did not have. She picked up her bag and went home. She updated the commission file until 11 p.m. She added the contempt order, the fine, the case name, the docket number. She added the count, 13, and a notation about the pattern, which now had enough density to support a preliminary structural conclusion that what she was observing in courtroom 4 was not a judge with a short temper or an aggressive style, but a specific and consistent practice of applying procedural standards in a way that functioned differentially based on the status and resources of the attorney appearing before him. That was a finding. It was not yet a formal finding, and it was not yet sufficient for a referral on its own, but it was the spine of one. She sent a secure message to the commission staff attorney at 11:17 p.m. She went to bed at 11:40. She was at the courthouse at 7:53. The chamber's invitation occupied more of her attention on the drive in than she would have preferred. The invitation was not an invitation. It was an assessment. Pressley had noticed her. Brennan had made sure of that, or Tessa had, or both, and he had decided to have a look at close range. The informal observation rotation was a mechanism for that look. It was also, potentially, an opportunity because proximity to Pressley in a setting with fewer structural barriers than the open courtroom was something she had been attempting to engineer through other means for 3 days. She would go. She would be careful. She went to the archive first. She had 2 hours before 10. In the archive, she returned to the transfer log she had photographed the day before. She read it again, carefully, looking for anything she had not fully processed on the first reading. There was a handwritten notation at the bottom of the page, not part of the printed log, but an addition in pencil, very faint, that she had not noticed before because she had been focused on the initials PH. The notation was a single string of numbers. She wrote it down in her notebook. 7 digits, arranged 3-4, not a case number, not a file reference, not a docket entry, a box number. She wrote, "Number format unknown, requires secondary reference," and below that, the secondary log. She returned the key at 9:45 and went upstairs. The chamber's suite was on the 2nd floor, accessible through a door requiring the restricted key card. Brennan Holt was waiting outside it when Celeste arrived, along with Tessa and Clara and the clerk who had delivered the invitation. The door opened at exactly 10 o'clock. Pressley's chambers was a room that had been designed to communicate something. The bookshelves were floor to ceiling and organized by category and within category by publication date, and the books were real, not decorative, not uniform, but accumulated, the evidence of someone who had been reading law for a long time and had not thrown anything away. The desk was large and clear. The window faced east, and in the morning the light came through it at an angle that illuminated the room, and also, depending on where you were standing, put you at a disadvantage looking toward the desk. Pressley was at the desk. He did not stand when they came in. He did not look up immediately. He finished reading whatever he was reading, set it down, and looked at them with the expression of a man who is satisfied with the arrangement of the room. The arrangement of the room was specific. There were 4 chairs in front of the desk, positioned so that the occupant sat slightly lower than Pressley's line of sight. Not dramatically, not enough to seem deliberate to someone who was not paying attention, but enough that over the course of 40 minutes the physical posture it required would produce a subtle and cumulative effect. Clara Nguyen sat in the rightmost chair, planner open. Tessa took the one beside her. Brennan took the chair nearest the window, which gave him the worst of the light angle, and which he would not have chosen if he had understood why it was positioned there. Celeste took the chair at the far left, which placed the bookshelf directly in her peripheral vision. On the 3rd shelf from the top on the left wall, she saw a volume she had not expected to see in a circuit court judge's personal collection, a casebook on judicial ethics and professional conduct, not the standard Virginia reference, but an older edition of a specialized academic text not in wide circulation. The kind of book you owned because you had studied it specifically, or because you wanted to understand the standards to which you were subject. She looked away. Pressley had seen her looking. "You find the collection interesting," he said. "The organization," she said, "by category and then by date, rather than alphabetically." He looked at her for a moment, a quality of assessment more direct than his courtroom manner. Here, in the room where he did not need to perform, he was looking at her the way you look at something you are trying to place. "You've been in my courtroom every day this week," he said. "Most sessions." "Why?" "I find the procedural dynamics instructive," she said. "Each case presents a different set of constraints." "What law school are you from?" "I'm not currently enrolled." A pause, longer than the first. He looked at Brennan, who was standing near the window with the expression of someone watching something he expected to find interesting. Then back at Celeste. "The archive inventory," he said. "Is it what you expected?" "It's what I was assigned." "That's not what I asked." She held his gaze. "The archive has gaps worth understanding," she said. "That's part of any inventory." "Gaps," he said. "Sequential anomalies. In the pre-2009 range. The coding transition creates ambiguity about whether what appears to be a gap is a structural feature of the old system or an actual absence of material." "And which do you think it is?" "I think it requires a secondary reference to determine," she said. "The primary archive record isn't sufficient on its own." He looked at her for 4 full seconds. Then he said, "You'll want to finish the inventory as assigned. The secondary reference question is outside the scope." "Of course," she said. He turned to the rest of them and began speaking about the court's caseload structure and the intern program's purpose and the general architecture of how a circuit court session flowed from initial filing to resolution. He spoke well and with precision, and it was clear that he had given this talk before, possibly many times. But midway through the talk, at a moment that appeared casual, as though the question had simply occurred to him, he stopped, looked at Celeste, and said, "Ms. Drummond, what is the Virginia standard for abuse of discretion in evidentiary rulings at the trial court level?" It was a test, the kind of question that sounds instructional but is not. The kind asked not because the asker doesn't know the answer, but because they want to measure the quality and speed of what comes back. She answered without pausing. "The appellate court will not disturb an evidentiary ruling unless the ruling is plainly wrong and not merely wrong. The standard requires showing the exclusion or admission was not a matter on which reasonable jurists could differ." The Virginia Supreme Court applied this consistently from the foundational treatment in Coe v. Commonwealth, and the Court of Appeals has tracked it closely in the civil context. The limitation is significant. Plain error review at the appellate level means most evidentiary challenges at the trial court fail on the standard alone, regardless of merit. A silence. Brennan Holt looked at his shoes. Clara Nguyen had stopped writing in her planner. Pressley's expression did not change. He held the silence for 2 seconds, then resumed the teaching narrative as though the question had not been asked and the answer had not been given, in the specific manner of a person who is not going to acknowledge that what just happened, because acknowledging it would require him to say something he is not yet ready to say. Brennan Holt nodded at intervals for the remainder of the talk. Clara Nguyen wrote notes. Tessa watched Pressley with the professional attention of someone calculating how to be useful. Celeste listened without appearing to be paying particular attention to anything. She was paying attention to everything. The talk lasted 40 minutes. At the end of it, Pressley looked at each of them in sequence, and when he reached Celeste, he paused 1 beat longer than he had for the others. "Ms. Drummond," he said. She looked at him. "How long have you been working with legal materials?" "Long enough," she said. It was not an answer. It was the kind of response that sends a signal while appearing not to, and the signal it sent was, "I know you are asking a real question, and I have chosen not to answer it." Whether Pressley read the signal correctly, she could not tell. His expression did not change. They were dismissed at 10:50. This is the part of the story where people tend to underestimate what is happening. The judge thinks he is evaluating an intern. The intern is building a file. One of those people is correct about what is actually going on. Keep reading. In the corridor, Brennan Holt fell into step beside Celeste. "You told him the archive has gaps," he said. "That's going to come back." She kept walking. "The archive has gaps. He's going to tell Cordero. Cordero already knows." A pause in the step. Then he resumed. "You're not making this easy on yourself." "I'm doing the assignment I was given," she said. "You're doing more than that, and everybody in that room knew it." His voice was still in the pleasant register, but something had shifted behind it. Not quite irritation, more like the recalibration of someone who has been treating a situation as simpler than it is. Pressley noticed. "That's not good for you." "Is it good for you?" she said. He stopped walking. She turned the corner at the stairwell and went downstairs. She was 2 flights down when she heard him on the landing above, not following, just standing there, which was different from following, but not different in the way that mattered, because the sound of a person standing very still above you on a stairwell carries in a specific way that has nothing calming about it. She did not speed up. She went back to the archive for the rest of the morning, working the inventory with methodical completeness. She made no new discoveries, nothing with the weight of the transfer log, but she continued to build the map, and the map was becoming something. At 12:15 she was in the archive when the door opened and Brennan came in. He did not say anything immediately. He came into the room in the manner of someone doing something perfectly reasonable, returning a file, checking a shelf, and moved to the shelving unit she had been working on. He set a folder on the shelf directly in front of the section she was working on, in the specific way you set something down when you want to make clear that you are claiming the space. She stepped back. He picked up the folder, opened it, appeared to read something, closed it, and replaced it on the shelf. The entire operation took 45 seconds. Then he turned and walked out without looking at her. She waited until the door closed. Then she went back to the shelf and looked at the folder he had placed there. It was a civil case from 2014. There was nothing in it that was connected to anything she was working on. He had come in, occupied her space for 45 seconds, and left. She wrote nothing in her notebook about this. She did not need to write it down. She filed it in the layer underneath the notebooks, with the things she kept because they were true, and because truth has a way of becoming useful. At 12:45 she put the folders away and locked the archive door and went to the lobby to get lunch from the vendor on the courthouse steps. She bought a sandwich and a bottle of water and ate outside in the afternoon warmth and thought about what she had. She had the transfer log with the initials, the case number from the envelope, the box number in a format she could not yet decode, the pattern of courtroom conduct she had been documenting, and Ruth Ellison, who was a thread she had not pulled directly yet. She did not have the identity of the case, access to the secondary storage, confirmation that the gap was what she believed it to be. She needed the secondary log. She went back inside. Ruth Ellison was in the lobby. This was unexpected. Ruth's domain was the clerk services area and the library, not the lobby, which was a transitional space. She was standing near the security desk with a cardboard box of files that she had apparently set down, either because it was heavier than expected or because she had decided to stop here for reasons of her own. Celeste crossed the lobby and took the box from her. "Second floor?" she said. Ruth looked at her. The look lasted a moment longer than necessary. Then, "The library." They rode the elevator together. The elevator at the Henrico County Circuit Court was original to the building's 1979 renovation, and it was slow. The ride from the lobby to the second floor took approximately 45 seconds, which is longer than it sounds when both people in it have things they are not saying. Ruth did not speak for the first 20 seconds. Then, without looking at Celeste, and at a volume precisely calibrated to carry no further than the elevator walls, "The archive closes at 4:30. The building closes at 6. Celeste held the box. "The second floor restricted wing," Ruth continued. "The keycard access was last updated in 2019. The override protocol for maintenance staff uses a different authentication. The override is logged separately from the standard access log." The elevator reached the second floor. The doors opened. "Third shelf from the left, past the circulation desk," Ruth said. "Cardboard box, brown, labeled 2004 Annual Reports." She took the box from Celeste and walked into the library without looking back. Celeste stood in the elevator doorway for a moment. Then the door sensor activated, and the doors began to close, and she stepped out. She went to the archive and requested the key and worked her inventory for 2 hours. She left at 4:28, 2 minutes before the archive closed. She returned the key. She went to the intern office and collected her bag. She said good evening to Clara Nguyen. She did not leave the building. She went to the library on the 3rd floor, still open because the library closed at 5:30, and sat at a back table and read. She stayed until 5:27, when the librarian began her closing sweep. She put away the volume and said good evening and walked to the stairwell. She did not go down. She went up. The 4th floor of the Henrico County Circuit Court housed administrative offices, the court administrator's suite, budget and finance, and 3 rooms listed on the building directory as storage. The 4th floor was accessible from the stairwell without a keycard. She had identified this on her 2nd day. She walked the 4th floor slowly, in the manner of someone who is looking for a bathroom and is not sure which door leads to one. 3 people remained at desks in offices with open doors. She passed them without engaging. She found the storage room at the end of the east corridor, unlocked, shelving units stacked with cardboard boxes. She turned on the light. 3rd shelf from the left, past the circulation desk. Ruth had said past the circulation desk, which was a library reference, not a storage room reference. This was not the right room. She turned off the light and stood in the corridor. The circulation desk. In a courthouse context, the closest analog was the clerk's records window. The clerk's records storage was in the restricted wing. She went back to the 2nd floor. The restricted wing entrance was at the end of the left corridor, past the double doors. She stood at the double doors. She had her intern badge. She did not have the restricted keycard. She heard, through the doors, a sound she recognized. The specific metallic sound of a filing cabinet drawer being opened and then closed. She waited. At 5:51, the double doors opened from the inside, pushed by a person managing them with their shoulder because their hands were full of folders. Lance Cordero. He came through and stopped when he saw her. They looked at each other. "The building closes at 6, he said. "I was on my way out," she said. He looked at her badge, at her bag, at her face. "The restricted wing," he said. "You don't have access." "I know. I was at the double doors. I heard someone inside and I waited to see if they needed assistance." He shifted the folders. He looked at her for a long moment with the expression of someone trying to determine whether a thing is true or whether it is the kind of true that is also a lie. "Ms. Drummond," he said, "what exactly are you looking for?" She held his gaze. She said, "I'm looking for the secondary log. I think it's in the restricted wing, and I think it would help me complete the inventory more accurately." His expression changed. Not quite anger. Something older than anger. Something that looked like a man who has been holding a door shut for a very long time and has just heard someone knock on it from the other side. "There is no secondary log," he said. "I was told there was," she said, which was not a lie. "By whom?" She did not answer. He looked at the double doors, and then at her, and then at the double doors again. "The building closes in 8 minutes, he said. She stepped back from the doors. He walked past her and down the corridor toward the clerk's office without looking back. She watched him go. Then she turned and went to the stairwell and went down to the lobby and signed out at 5:57. Outside, the evening was warm and the street was beginning its end-of-day shift. She stood on the courthouse steps and thought about Cordero's expression when she had named the secondary log. He had not said she was wrong. He had said the log did not exist. Those were different statements. She went to her car. She drove north for 6 blocks and parked and sat with the engine off. The box number from the transfer log was still in her notebook. She looked at it again. 7 digits, 3-4, a box number. 3rd shelf from the left, past the circulation desk. Brown cardboard box, labeled 2004 Annual Reports. The kind of label you put on a box when you do not want anyone looking for what is inside it to find it. She needed to get into the restricted wing. Before she started the engine, she heard something she was not supposed to hear. The parking structure adjacent to the courthouse had a pedestrian walkway that ran parallel to the lane where she was parked, separated by a low concrete wall and a line of vehicles. The walkway was not visible from the street, but was visible from a car parked in the 2nd row, which was where she was. Brennan Holt and Tessa Garfield were on the walkway, standing close, in the specific posture of people who believe they are not being observed. She did not roll down her window. She did not need to. The parking structure had acoustics that carried voices the way old buildings carry voices, through concrete and angle rather than through air, so that she heard fragments rather than sentences, but the fragments were enough. Tessa's voice. Something about the archive. Something about what Celeste had been asking Cordero. Something that contained the phrase, "not just an intern." Brennan's voice, lower, and the lower register carried less cleanly, but she caught, "Pressley needs to know before," and then a car engine elsewhere in the structure took the rest of it. Tessa again. She cited, and then, "that commission thing." She held very still. She had cited Virginia Code Section 17.1-913 in conversation with Warren Oakes. Oakes had not asked her to clarify. She had assumed Oakes had not shared what he heard. That assumption appeared to have been wrong, or someone else had heard it, or the commission reference had reached Tessa through a different channel she had not mapped. Brennan and Tessa moved on, their voices receding into the structure's ambient noise. She sat in the car for a moment. Then she started the engine and drove toward the commission office. She had 12 minutes before she needed to be there. She thought about the sequence of events. Tessa knew about the commission citation. Tessa would tell Pressley. Pressley would respond in some form, and the form would likely involve the archive assignment and the question of what she was actually doing there. Whatever that response was, it would happen before tomorrow's commission meeting, or it would happen after, and the timing mattered because the commission file was not yet complete, and a premature confrontation was a risk she had not fully priced. She pulled onto the main road. She had one option she had not yet used. She could request emergency authorization from the commission to disclose her status to Cordero and Pressley directly. That would end the observational phase of the investigation and move it into a formal inquiry posture. She was not ready for that. The evidence was not yet sufficient to support a formal inquiry finding, and a premature formal inquiry could give Pressley's attorneys the procedural basis to challenge the whole proceeding. She needed the box. She needed Ruth. She drove toward the commission office and thought about what she was going to say to the commission staff attorney about the pace of the investigation and the risk she was now managing, and she thought about whether she had underestimated how quickly this building would close around her. And she concluded that she had not underestimated it, exactly, but that she had not fully anticipated the specific form the closure would take. She was 12 minutes early. She sat in the anteroom outside the conference room and took out the commission file and read through it and thought about what she was going to say and what she was not going to say and what Commonwealth versus Okafor D meant for the shape of both. At 2 o'clock exactly, the door to the conference room opened. She went in. The meeting lasted 90 minutes. She presented the first 2 items quickly, procedural updates that the commission staff attorney confirmed and logged without extended discussion. The third item took most of the session. She walked the commission through what she had: the documented pattern of conduct, the 13 incidents, the contempt order and fine, the courtroom architecture she had observed, and, carefully at the end, the transfer log, the gap in the archive sequence, and the case number that corresponded to a criminal matter from 22 years ago. She did not say what she believed the transfer log meant. She presented it as documented evidence of an administrative action bearing initials she could not yet attribute, taken within a time frame that corresponded to the period she was investigating. The commission staff attorney, a woman of about 45 named Philippa Kaur, who had been in this role for 11 years and had the specific quality of attention of someone who has heard people present evidence in carefully calibrated portions many times, said, "What's the source on the case number?" "An envelope I found posted on a courthouse docket board," Celeste said, "addressed to my function." A silence. "And the transfer log bears whose initials?" "P and H. I don't have confirmation of attribution yet." Kaur wrote something. She looked at the transfer log photograph on the tablet Celeste had provided. She looked at Celeste. "How close are you to the supplementary storage?" she said. "I need the restricted wing. I don't have the access." "Timeline for getting it through standard means?" Cordero controls the authorization process. He denied me access this week. Cor set down her pen. We can issue a formal document request under Section 17.1-913, which would compel production from the court's administrative office within 15 days. But that discloses the investigation. She paused. Or you keep working the observational phase and find another route. I have a route, Celeste said. I need 2 more days. Cor looked at her for a moment. Then she looked at the case summary for Commonwealth verses. Okafor, D., that Celeste had included in the file. The defendant, she said. What happened to him? Paroled after 14 years. Primary witness recanted. No exoneration proceeding was initiated. Why not? The public defender office at the time determined the recantation alone was insufficient to support a successful petition without additional evidence. The evidence was in the archive. The archive was managed. She used the word carefully. Cor was quiet for a moment. 2 days, she said, and then we talk about whether to disclose. Celeste said she understood. She gathered her materials and left the commission office at 3:45 and drove back toward the courthouse, not because she needed to be there at this hour, but because she was thinking and thinking for her required movement. She drove past the courthouse without stopping. She drove for 20 minutes, out along the river road, where the James ran brown and fast between its banks in the early summer. And she thought about Darius Okafor, who had spent 14 years in a Virginia correctional facility because a witness had said something in a courtroom, and a judge had allowed the case to proceed, and the evidence that might have changed the outcome had been managed into a box with a wrong label in a room she could not access. She turned around and drove home. She worked on the commission file until midnight, then she went to bed. She was at the courthouse at 7:49 on Thursday morning. The second floor was quiet. The intern office was empty. She put her bag down and went to the window that faced the interior courtyard and stood there for a moment, looking at the maintenance workers setting up equipment below, and thought about the restricted wing and Ruth's directions and the box number and whether 2 days was enough. Warren Oakes came into the intern office at 8:12. This was unusual. Oakes's path through the building did not typically include the intern office. He came in and stood in the doorway and looked at the room, which contained only Celeste, and then he came in fully and closed the door. He did not sit. Not. I heard something last night, he said. She turned from the window. I overheard a conversation, he said, in the parking structure. It wasn't a conversation I was meant to hear. She waited. He looked at the floor for a moment. Then he looked at her. Warren Oakes had 28 years in this building, and the face of someone who has spent those years keeping the peace between the thing that is right and the thing that is required. The face of someone who has chosen, more times than he would have liked, the thing that is required. The citation you made in the library, he said, Section 17.1-913. Yes. That's a JIRC provision. Yes. He was quiet. Tessa Garfield heard you cite it, he said. She told Brennan Holt. Brennan told Pressley last night. She absorbed this. Pressley is going to do something, Oakes said. I don't know what. I know he spent 45 minutes on the phone last night with the Bar Association's senior counsel. I know that because I was in the building late and I heard him through the door to chambers. He was asking about the legal basis for removing an intern from a courthouse program. She looked at him. She looked at him for long enough that he looked slightly away. Mr. Oakes, she said, why are you telling me this? He was quiet for another moment. Then, 31 years ago, this courthouse had a case. A young man. He was 24 years old, and he didn't do what they said he did, and the person who could have stopped the trial from proceeding made a different choice. He straightened his jacket. I was the deputy clerk on that case, he said. I was 27 years old, and I didn't understand what I was looking at until it was finished. And then I understood, and I did nothing, and I have been doing nothing for 31 years because doing nothing is the easiest thing in the world in a building like this. He paused. Until it isn't. He walked to the door. He opened it. Pressley is going to move today, he said. Whatever you need to do it this morning. He left. She stood in the empty intern office and looked at the closed door. Then she picked up her bag and went to the third floor and found the library and went to the reference desk and said to the librarian, "I need to look at the secondary reference materials for the pre-2009 archive classification system. I was told there might be a supplementary guide." The librarian, a man of about 60 with reading glasses on a cord, looked at her. He looked at her badge. He said, "One moment," and went through the door behind the reference desk. He came back 3 minutes later. He set a thin binder on the counter, gray cardboard, unlabeled, old. He said, "Return it when you're done." She took it to the back table and opened it. The secondary classification guide for the pre-2009 archive system was 17 pages long and had been last revised in 2005 and used a coding logic that cross-referenced case type, court division, and a 4-digit box assignment number that identified the specific physical storage location within the restricted supplementary storage wing. The box number from the transfer log, 7 digits, 3-4, resolved, using the guide's logic, to a specific location: restricted supplementary storage, Division HC4, Shelf 3, Position 7, Division HC4, Courtroom 4. She read this twice. Then she closed the binder and returned it to the reference desk and said thank you and walked back downstairs. At 9:48 in the morning, 40 minutes before she was supposed to leave for the afternoon continuation of yesterday's commission session, Pressley's clerk appeared in the intern office doorway. He held out a manila folder. "Judge Pressley asked me to give this to Ms. Drummond," he said. She took it. Inside was a 2-page summary of a case, printed from the court's internal system. The case was captioned, Commonwealth vs. Okafor, D. The date on the summary was 22 years ago. At the bottom, in Pressley's handwriting, she had seen enough of the courtroom paperwork to recognize it, was a single line: Research project. Report back in 2 weeks. She looked at the folder. She looked at the clerk, who was already leaving. The name Okafor, D, landed in her chest with the specific weight of something arriving rather than being found. She had been looking for the case number from the envelope. The case number had led her to a transfer log. The transfer log had led her to a box number she had now decoded. And now the judge himself had handed her the file summary, apparently as a research task he considered impossible, a dead end dressed up as an assignment. She thought about what Oakes had said. Pressley had spent 45 minutes last night on the phone exploring legal grounds to remove her from the program. He had not removed her. He had given her a research assignment instead, which meant he was not certain yet. He was still trying to determine what she was and whether she was a threat. The Okafor assignment was simultaneously a test and a trap. If she could not find the full record, she would fail the test and he would conclude she was an unusually well-read intern who had gotten lucky with a statute citation. If she found the full record, if she got into the restricted wing, she would reveal that she had capabilities and access she should not have, and he would use that to remove her. Or he did not know that the full record was in the restricted wing. He believed it was gone. She closed the folder and put it in her bag next to the black notebook. She picked up her bag and left the building. She had 28 minutes to get to the commission office. She walked out through the glass doors and into the Richmond morning and thought about all of it. The box number, Okafor, Oakes at the door, the 45 minutes of phone calls, and the specific sequence of moves available to her now and what each one cost. She got into her car. She sat in the driver's seat and opened the folder and read both pages carefully, one more time. Commonwealth vs. Okafor, D felony. Murder in the second degree. Convicted. 18-year sentence. Paroled after 14 years when the primary witness formally recanted. No exoneration. No vacatur. The record was closed. At the bottom of the second page, in the summary field marked Case Status, were 3 words: Adjudicated. File archived. She closed the folder. She started the engine. She was 12 minutes early. She sat in the anteroom outside the conference room and took out the commission file and read through it and thought about what she was going to say and what she was not going to say and what Commonwealth versus Okafor D meant for the shape of both. At 2 o'clock exactly, the door to the conference room opened. She went in. The meeting lasted 90 minutes. She presented the first 2 items quickly, procedural updates that the commission staff attorney confirmed, and logged without extended discussion. The third item took most of the session. She walked the commission through what she had: the documented pattern of conduct, the 13 incidents, the contempt order and fine, the courtroom architecture she had observed, and the secondary classification guide's decoding of the box number that now gave her a precise location for the physical record. The commission staff attorney, a woman named Philippa Corr, who had been in this role for 11 years and had the specific quality of attention of someone who has heard people present evidence in carefully calibrated portions many times, looked at the box location notation and said, "You have the location, but not access." "Not yet." "What's your timeline?" "Tomorrow morning," Celeste said. Corr looked at the table for a moment. She was the kind of person who processed out loud when she was deciding, and she processed now. The formal document request under 17.1-913 would take 15 days and disclose the investigation. You have the location. You have the secondary guide decoding. You have the initials on the transfer log. What you don't have is the box itself. What's in it will determine whether the Brady violation was isolated or instructed, meaning whether it traces to Pressley. Yes. Corr wrote something in her file. She said, "Tomorrow morning. You have until Monday for confirmation. If we don't have the physical record by Monday, we issue the formal document request and accept the procedural risk." Celeste said she understood. She drove back toward the courthouse in the late afternoon, not because she needed to be there at this hour, but because she was thinking, and thinking required movement. She parked 3 blocks from the building and walked past it, and continued walking for 20 minutes, out along the river road where the James ran fast between its banks in the early summer, and she thought about Darius Okafor. Darius Okafor had been 24 years old when he was convicted. He had served 14 years before the primary witness recanted formally, in writing, with a sworn statement that contradicted the trial testimony on 3 specific points. The public defender office at the time had determined the recantation alone was insufficient for a successful post-conviction petition. They were not wrong. Recantations are routinely discounted by appellate courts without corroborating evidence. The corroborating evidence was in a box in the restricted wing of the Henrico County Circuit Court, under a label that said 2004 Annual Reports, on the 3rd shelf to the left of the circulation desk equivalent, in Division HC4. Okafor had been paroled 6 years ago at the age of 47. He was not exonerated. His record was not cleared. Wherever he was living with the weight of a conviction that had not been vacated, for something she was now reasonably certain he had not done, because a witness had said something in a courtroom, and a judge had allowed the case to proceed, and the memo that would have changed the outcome, the Brady material, the document that proved the prosecution had withheld evidence, had been put in a box with a wrong label. She turned around and walked back to her car. On the way home, she stopped at the copy shop on Grove Avenue, the one that stayed open until 8 p.m., and made certified copies of everything she had: the transfer log photograph, the secondary classification guide pages she had photographed on her phone, the decoded box location, and the 2-page summary of Commonwealth versus Okafor, D. She sealed them in 3 separate envelopes and put 2 of them in her bag and mailed the 3rd from the box on the corner, addressed to the post office box she kept for this purpose. She got home at 7:30. She made something to eat. She sat at the desk and opened the commission file and read the structural argument she had written the night before and added to it: the commission meeting summary, the deadline, the location, the Okafor case details. At the bottom of the structural argument, she added one more line: if the physical record at HC4, Shelf 3, Position 7 contains what the transfer log and the secondary coding system suggest it contains, the formal inquiry referral will be complete. If it does not, if the box has been emptied or the material has been destroyed since the 2009 transfer, the investigation returns to the conduct pattern alone, which is sufficient for censure, but not for the Okafor referral to the Attorney General. She looked at this for a moment. Then she saved the file, closed the laptop, washed her cup, and went to bed. She lay awake for 20 minutes thinking about the sound of the filing cabinet drawer she had heard through the restricted wing double doors the previous evening, the specific sound of a metal drawer opening and closing. She thought about whether Cordero had been retrieving something from the restricted wing at 5:45 in the evening or returning something. She thought about the distinction between those two things. Then she slept. She was at the courthouse at 7:51 on Friday morning. The building had the particular quality of end of week, slightly lighter traffic in the lobby, a different security guard, the smell of coffee stronger than usual from the break rooms, as people compensated for the accumulated fatigue of 4 days. She signed in and went upstairs and found the intern office empty, and her table as she had left it. She had 3 things to do today, in the order they needed to happen. The first was the morning archive session, the inventory, the work she was assigned, the work she needed to appear to be doing. The second was finding a way into the restricted wing before the close of the building's administrative hours. The third was being available if Pressley moved, because Oakes had said Pressley was going to move and Pressley had not moved yesterday, and the delay made whatever was coming more deliberate, not less. She went to the clerk's office and signed out the archive key. Cordero was behind the counter. He did not hand her the key immediately. He set it on the counter between them and put one hand on it and said, "A word, Ms. Drummond." She waited. "The secondary reference guide for the pre-2009 classification system," he said. "The library logged its use yesterday morning. Your library card was on the access record." She said nothing. "That guide is an internal administrative document," he said. "It's not generally available. The librarian should not have provided it without authorization from this office." "He provided it," she said. "I returned it." "What did you use it for?" She looked at him steadily. "I used it to understand the classification system I'm working within. The inventory assignment requires me to understand what I'm inventorying." The hand on the key did not move. "The secondary guide provides location codes for restricted supplementary storage," he said. "Not for the main archive. You don't have access to restricted supplementary storage." "I know," she said. "Then I'm not sure why you needed the location codes." She held his gaze. "I needed to understand why certain case numbers from the pre-2009 period don't have corresponding files in the main archive. The secondary guide explains the routing, when material was transferred to supplementary storage rather than retained in the main archive. That's relevant to the inventory." He looked at her for a long moment. His hand remained on the key. The specific quality of what was in his face was not something she could fully read. It was not quite anger, and it was not quite fear, but it was in the vicinity of both. Then he moved his hand, and she picked up the key. 4:30, he said. "No exceptions." She went to the archive. She worked until noon. She returned the key. She went to the library and ate her lunch at the back table. At 1:15 she went back downstairs. She went to the restricted wing double doors and stood in front of them. The maintenance override that Ruth had mentioned, the separate authentication system, logged separately from standard access, required a specific protocol she had researched during her lunch break, using the courthouse's publicly available facilities management document, which was posted on the Virginia Court Administration's transparency portal and described the override system in terms specific enough to be useful. She did not use the override. She had decided that the evidentiary risk of entering the restricted wing through a maintenance override was too high. Any documentation of the access could be used to challenge the chain of custody of whatever she found inside. What she needed was either authorized access or a witness to a lawful entry. She stood in front of the double doors. Then she turned and walked to Cordero's counter. "I need to formally request access to restricted supplementary storage," she said, "for the purpose of completing the archive inventory. Specifically, I need to examine the contents of box HC437 to determine whether the material it contains falls within the scope of the inventory assignment." He looked at her. He looked at her for so long that the silence became a kind of statement. "That request," he said, "requires authorization from the senior clerk and counter-signature from the court administrator." "I understand. I'm making the request formally. Will you log it?" He took a form from a drawer. He filled in the date and her name and the box reference, HC 437, and he looked at the box reference as he wrote it, and something in his face changed, very slightly, in a way she filed away. He had recognized the number, not because he had memorized every box in the restricted wing, but because this number specifically was one he had reason to recognize. He stamped the form and handed her a copy. "Processing time is 3 to 5 business days," he said. "Thank you," she said. She folded the form and put it in her bag. She had the formal request on record. She had the box number on a time-stamped official document. She had Cordero's recognition of the number, which she had read correctly, and which told her the box still existed and had not been emptied or destroyed. She went back upstairs. She had 2 hours before the building closed. She had 2 hours before the building closed. She went to the intern office and sat at her table and thought, and what she thought was this: that the formal access request, once logged, gave Cordero and Pressley advance notice of exactly what she was trying to reach. That notice would give them time to do something about it, to claim the box had been sent to an off-site storage facility, to initiate a transfer, to log a destruction of records under some procedural mechanism, any of which would complicate what she needed to accomplish. She had moved too openly. She had made the formal request because the evidentiary chain mattered, but she had shown her hand doing it, and showing her hand at this point in the process was the one thing she had not meant to do. She sat with this for a moment. Then she took out her phone and called Philippa Core. "The box exists," she said when Core picked up. "I have the reference on a logged formal access request." Cordero recognized the number. "You filed a formal request?" Core's voice was careful. "Yes." A pause. "That gives them notice." "Yes," Celeste said again. "How quickly can they move the box?" "I don't know. I don't know the internal transfer protocol for restricted supplementary storage. I'd guess they could initiate a transfer in a day, complete it in 2 or 3. "We need to accelerate," Core said. "I'll issue an emergency preservation order under Section 17.1-902 today. That prohibits the destruction, alteration, or transfer of any records subject to a JIRC inquiry. It discloses the investigation, but at this point you've already disclosed your hand through the access request." Celeste held the phone. "Do it," she said. "It'll be served on the court administrator's office by end of business today," Core said. "Once it's served, Pressley will know there's a formal JIRC inquiry. He'll know it's been ongoing. He'll know—" She paused. "He'll know it was you." "I know," Celeste said. "Are you all right with that?" She looked at the wall of the intern office. She looked at the buzzing fluorescent light above her. She thought about the sound of the filing cabinet drawer at 5:45 on Thursday evening. "Yes," she said. She ended the call. She picked up her bag and her legal pad and her pen. She capped the pen carefully, the way she always did, and put it in the tote's front pocket. She looked at the room one more time, the 2 long tables, the desk lamps, the whiteboard with the schedule, the window that faced the courtyard. Then she walked out. In the corridor, she passed Warren Oakes, who was coming from the direction of the clerk's office. He stopped when he saw her. He looked at her face and appeared to read something there that she had not consciously put there. "You made the request," he said. "I made the request," she said. He nodded once. Not the filing nod, not the processing nod. A different kind of nod. The kind that means, "I understand what that costs, and I am acknowledging it." She walked past him and went down the stairs and out through the glass doors. The Richmond afternoon was warm and direct, the kind of June afternoon that doesn't apologize for itself. She stood on the courthouse steps for a moment and looked at the street and at the river 4 blocks south, visible between buildings as a line of glitter in the early evening light. Then she went to her car. Whatever was coming next would come from a different direction than what she had been managing. It would come faster, and it would be less predictable, and it would require her to be more visible than she had been since the day she walked into this building. She started the engine. She was ready for that.